Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 19, we're shifting gears a bit in part 2, public records. We've spent a lot of time on what constitutes a public record and which entities are covered. Now, we're going to dive into the practical side. D, providing public records. This section, covering pages 163 through 178 of your manual, outlines in incredible detail how public records are actually requested, handled, and provided by agencies. This is a crucial segment for both requesters and public employees. To give you the maximum granularity, this episode will be significantly longer than our usual 15 minutes. Let's start with the basic ground rules for accessing these records. Segment 1, D, providing public records. Validity of agency conditions, authorized individuals, purpose of request and role of custodian, pages 163 to 166. Starting on page 163, we begin D, providing public records. This section gets right into the nuts and bolts of how agencies actually respond to your request for information. First one, validity of agency conditions on Access 1 on page 163. While the Public Records Act gives everyone a broad right to access, it's not a free-for-all. Agencies have the right to set reasonable conditions for access. What does reasonable mean here? It means they can establish rules designed to protect the integrity and safety of the records themselves, to prevent disruption of regular office functions, and to maintain order within their facilities. For example, an agency might require you to inspect records only during their normal business hours, not at midnight. Review records in a specific designated area of their office, perhaps a conference room or a public counter, rather than wandering through employee workspaces. Do so under the supervision of agency staff who can ensure the records aren't damaged, altered, or removed. Use specific equipment like a dedicated computer terminal for electronic records. However, these conditions must be genuinely reasonable and transparent. They absolutely cannot be used as a tactic to frustrate or effectively prevent public access. An agency can't set conditions that make it practically impossible or unduly burdensome for someone to get the records they're entitled to. For example, they couldn't require you to review records only between 1 p.m. and 1:15 p.m. on a Tuesday if the request is voluminous. The case of State ex Ariel, Davidson versus Couch, 196 Southern 808, Florida, 1940, established that agencies can indeed impose reasonable regulations, but only those truly necessary to prevent disruption of their governmental functions. The key is balance. Protect the records and operations, but don't obstruct the public. Next, on page 164, we look at 2. Individuals authorized to inspect and receive copies of public records. 2. This is a simple but incredibly powerful point, and a cornerstone of Florida's law. Any person is authorized to inspect and receive copies of public records. The law makes absolutely no distinctions based on who you are. This means it doesn't matter if you're a Florida resident or from another state, a U.S. citizen or not, a journalist, a researcher, a business owner, or simply a curious individual. As long as you're a person, you have this fundamental right. You don't need a special interest, connection, or reason to ask for public records. Then on page 165, we tackle 3. Purpose of request, 3. This is another straightforward but absolutely vital point. A public agency cannot legally require you to state the purpose or reason for your public records request. Your motive, your intentions, or your ultimate use for the record are generally irrelevant to your right to receive it. Agencies cannot ask, "Why do you want this?" or "What are you going to do with these records?" and then deny your request if they don't like the answer or if you refuse to provide one. This is explicitly stated in law and has been consistently upheld by courts to ensure that the public's right to know is not contingent on justification, fear of scrutiny or approval by the agency. The classic case for this fundamental principle is Hewitt versus State ex rel. Hewitt, 174 Southern, 91, Florida, 1937. The motive of the person making the request is irrelevant to their right to access. This protects the free flow of information and ensures accountability. Finally, for this segment on page 166, we cover 4. Role of the records custodian, 4. The records custodian is the person, or sometimes the office, officially designated by the agency to be responsible for public records. This could be an agency head, a city clerk, a county attorney's office, a specific records manager, or another official. The records custodian has significant and legally mandated duties, which include ensuring that public records are properly maintained and organized, providing access to public records upon request, applying any legal exemptions or confidentiality provisions when necessary, and doing so correctly, being the primary point of contact for public records requests. They play a crucial role in upholding transparency and ensuring the agency follows the law. Their duty is a legal obligation, not just an administrative task. Segment 2, D, providing public records, copies versus inspection, multiple agencies, records not in possession, and overbroad requests, pages 167 to 168. Let's continue on page 167 with more aspects of how public records are provided. First 5, request for copies versus request to inspect public records, 5. The law generally gives you, the requester, the option to either simply inspect the records, meaning view them in person, typically without paying a copying fee, or to request actual copies, either paper or electronic. Agencies must provide access for both options, subject to their reasonable conditions and any applicable fees for copies. A key point here, if an agency maintains the record in an electronic format, they generally must provide it in that electronic format if requested, unless doing so would be impossible or unduly burdensome. You can't be forced to take paper copies if the record exists digitally. Also on page 167, we have 6. Records maintained by more than one agency, 6. This is a practical point for requesters. If a public record is created by one agency but then also shared with or maintained by another agency, for example, a consultant's report submitted to a city council and a copy also given to the city manager's office, you can typically request that record from any of the agencies that maintain a copy. Each agency holding the record has an independent duty to respond to the request. This prevents a requester from being bounced around between different departments or agencies, making it easier for you to get the record you need. Still on page 167, we look at 7. Records not in physical possession of agency, 7. This point is increasingly important in our digital age. An agency's public records don't have to be physically located within their walls, in their filing cabinets, or even on their own government servers to be accessible. If the agency has legal access to or control over records, even if they are stored by a third-party vendor, like in a private cloud computing service as we discussed in episode 18, temporarily held by an employee on a personal device, like text messages on a private cell phone if they pertain to public business, located remotely but under the agency's authority. These records are still considered public records of the agency and must be provided upon request. The agency cannot avoid disclosure by simply not having the records in its immediate physical possession. Their duty is to produce any record related to official business that they have the right to access. Moving to page 168, we discuss 8. Overbroad. Public records requests, 8. This is a very common point of contention and can sometimes slow down the request process. A request might be considered overbroad if it asks for an extremely large, unmanageable volume of records that would take an unreasonable amount of time or resources to compile. It's so vague or general that the agency cannot reasonably identify what specific records are being sought, e.g., all documents about everything, While agencies cannot use overbroad as an automatic excuse to simply deny a request outright, they can ask for clarification from the requester. They generally have a duty to assist the requester in formulating a request that can be reasonably fulfilled. This might involve working with the requester to narrow the scope, define specific search terms, or specify timeframes. The Florida Supreme Court in State ex rel. Williams v. Cornwell, 97 Southern 2nd, 607, Florida, 1957, affirmed that agencies are not required to do research for the requester or create records that don't exist, but they should assist in clarifying requests. Segment 3. D. Providing public records, written form requirements, identification, remote access and request to create, answer, pages 169 to 171. Let's continue on page 169 for more details on how requests should be made and fulfilled. First, 9. Written request or form requirements, 9. This is an important practical point for requesters. Generally, a public records request in Florida does not have to be in writing. You can often make a request verbally, even over the phone or in person. However, agencies can ask for a written request. They often do this especially for complex or voluminous requests to help ensure clarity about what's being asked for and to create an accurate record of the request itself. Some agencies might also provide optional forms for requests on their websites or at their offices, but they cannot legally require you to use a specific form or submit a written request unless there's a specific statute or administrative rule that specifically allows them to impose that requirement for that particular type of record. The guiding principle here is to avoid creating unnecessary burdens on the requester. Next, on page 169, we have 10. Identification of requester, 10. Similar to not having to state your purpose, a public agency cannot generally require you to identify yourself when making a public records request. You have the right to remain anonymous if you choose. The only rare exceptions would be if a specific statutory exemption for a particular type of record explicitly requires identification for access. For example, some highly sensitive health records might require you to prove you are the subject of the record. This ensures that fear of retaliation, harassment, or scrutiny does not deter individuals from seeking public information. The principle of anonymous access is a cornerstone of public records law. Moving to page 170, we discuss 11. Remote access, 11. This topic has become increasingly relevant with the digital age. With the vast majority of public records now existing in electronic formats, agencies are increasingly expected to provide remote access to public records. This is often done through their official websites, online portals, or dedicated public records request systems. While it's not always a strict mandate for all records to be immediately available online, especially very old or obscure ones, the law strongly encourages agencies to automate and make records available online where feasible. This proactive approach significantly enhances transparency by making access easier and faster for the public, reducing the need for time-consuming in-person visits or mailed copies. The overarching goal is to maximize convenience for the public in accessing information. Also on page 170, we cover 12. Request to create new records, answer questions about the records, or reformat existing records, 12. This is a very important limitation on an agency's duty under the Public Records Act. The Act generally requires agencies to provide access to existing public records. It does not compel agencies to create new records. If the specific information you want doesn't exist in a pre-existing record format, the agency doesn't have a duty to generate a new document or report just for your request. For example, they don't have to create a custom data report from raw data if that report doesn't already exist. Answer questions about the records. Agencies are not required to interpret records, explain their meaning, summarize their content, or answer questions about their implications. Their duty is to provide the existing record itself. Interpretation is left to the requester. Reformat existing records. While agencies should provide records in the medium they are routinely maintained, e.g., if they have it as a PDF, they should give you the PDF, they are generally not required to reformat records into a completely different format just because a requester asks for it, e.g., turning a complex spreadsheet into a simplified graph, unless they already have the existing capability to do so easily, or if it is their normal operational practice. The exception here is that if an agency maintains a record in an electronic format and the requester asks for it in that electronic format, the agency generally has to provide it in that format as per Section 1, 19.07, subsection 1, paragraph D, Florida statutes. This means if they have it digitally, you can usually get it digitally. The agency's duty is to provide access to what is, not to create what isn't or to interpret what is provided. Finally, for this segment, on page 171, we have 13. Records available in more than one medium, 13. If an agency maintains a public record in multiple forms, for example, they might have both physical paper copies and digital scanned versions of the same document, and a requester asks for it in a specific medium, the agency should provide it in that requested medium if it's reasonably possible and available. They can, of course, charge the applicable fee for the chosen medium. The agency isn't obligated to create a new medium just for the request, but if they already possess it in various formats, they should accommodate the requester's preference for accessibility. Segment 4, D, providing public records. Time allowed for response and confidentiality agreements. Pages 172 to 174. Now let's talk about page 172 and a very common question, 14. Amount of time allowed for response to public records requests, 14. This is often a point of confusion because the Public Records Act doesn't specify an exact number of days within which an agency must respond to a request. Instead, it requires agencies to respond within a reasonable time. What constitutes reasonable depends entirely on the circumstances of each individual request. Let's break down what reasonable time truly means. A duty to acknowledge requests promptly, 14A, on page 172. While there's no hard numerical deadline for full fulfillment, agencies absolutely have a duty to at least acknowledge requests promptly. This means they shouldn't ignore requests or leave requesters wondering if their request was received. A quick confirmation that the request is being processed is expected. B, automatic delay impermissible, 14.B, on page 172. An agency cannot have a blanket policy that imposes an automatic fixed delay on all requests, e.g., we respond to all requests within 10 business days, no matter what. Responses must be handled on a case-by-case basis, with the agency actively working to fulfill simple requests as quickly as possible, even immediately if the records are readily available. C, unjustified delay, 14.C, on page 172. Any delay in fulfilling a public records request must be justified and explained by the agency. If a request is simple and the records are readily available, e.g., a single document that's already digitized, a response should be very quick, perhaps within hours or a day. If the request is complex, involves searching through many records, requires extensive redaction for confidential information, or involves older archived materials, then more time is certainly reasonable. However, the agency must be actively working to fulfill the request, not just letting it sit. They should communicate any reasons for delay to the requester. D, arbitrary time for inspection, 14.D, on page 173. Agencies cannot set arbitrary or excessively short times for inspection that effectively prevent a requester from adequately reviewing records. For example, if a requester asks to inspect a large volume of records, the agency cannot reasonably limit their inspection time to just 30 minutes if that's clearly insufficient. The time provided for inspection must be genuinely reasonable to allow for a thorough review. Moving to page 174, we have E, standing request for production of future records, 14.E. This clarifies an important limitation. Generally, an agency is not required to honor a standing request for all future records of a certain type as they are created. For example, you typically cannot make one request today and expect to continuously receive all city council emails for the next year as they are created. You usually have to make a new request for records that are created after your initial request. The agency's primary duty is to provide access to existing public records at the time the request is made. While some agencies might offer subscription services for certain public data, they are not legally obligated to do so for all records. Finally, for this segment, on page 174, we discuss 15. Confidentiality agreements. 15. This is a very critical principle. If a public agency enters into a contract or any other agreement that contains a confidentiality clause with a private entity or another party, that confidentiality clause generally cannot override the Public Records Act. This means public records cannot be made confidential simply by mutual agreement or contract unless a specific state statute explicitly creates an exemption for those particular records. The agency cannot use a private agreement to circumvent the public's constitutional and statutory right to access. This reinforces the core principle that records are open unless specifically exempted by law, not by private agreement. Any contract attempting to make public records confidential where no statutory exemption exists would be unenforceable under the Public Records Act. Segment 5, D, providing public records, redaction, privacy rights, and liability for disclosure, pages 176 to 178. Let's move to page 176 for our final and crucial segment on providing public records. First, 16, redaction of confidential or exempt information, 16, on page 176. This is a very common and essential process that agencies must perform. If a public record contains a mix of both public information and legally confidential or exempt information, the agency must redact, meaning black out, obscure, or remove, only the specific confidential or exempt portions, and then provide the rest of the record to the requester. They cannot withhold the entire record just because a small part of it contains confidential information. Agencies are also legally required to state the specific legal basis for the redaction, the exact statute that makes the information confidential or exempt. Provide a written explanation of how the exemption applies. This ensures maximum transparency while strictly protecting legally confidential information. Section 1, 19.07, subsection 2, paragraph A, Florida statutes, explicitly allows for and governs this redaction process, specifying how agencies must respond when records contain both public and exempt information. The idea is to release as much as possible while complying with confidentiality mandates. Next, on page 177, we discuss 17, privacy rights, 17. While Florida has a very broad public records law, the state constitution also has a fundamental right to privacy. Florida Constitution, Article 1, Section 23. This constitutional right to privacy is sometimes invoked in public records disputes, particularly when personal information not explicitly exempt by statute is at stake. Courts then have to perform a delicate balancing act between the public's strong right to know and an individual's constitutional right to privacy. The manual explains how this balance is typically struck, noting that while statutory exemptions usually govern, constitutional privacy can provide an additional layer of protection for highly sensitive, purely private information that has absolutely no relation to official public business. It's a very high bar to meet, but it acknowledges that not all personal information should be public. Finally, for this episode, on page 178, we cover 18. Liability for disclosure, 18. This addresses the legal risks for agencies and their employees when handling public records. Public employees and agencies are generally not liable for civil or criminal penalties for releasing public records that are legitimately public, even if the release happens to cause some unforeseen harm or embarrassment to an individual. The law provides a degree of immunity for good faith disclosure of non-exempt public records. This protection is crucial because it encourages agencies and their staff to comply with the law and err on the side of transparency without fear of frivolous lawsuits. However, it's equally important to understand that agencies and employees can be held liable for unauthorized disclosure of records that are explicitly confidential or exempt by law. This creates a strong incentive for agencies to carefully and correctly apply exemptions, ensuring that truly protected information remains so, while reassuring them when they are fulfilling their core duty to release public records. It encourages transparency without creating undue risk for employees acting in good faith to follow the law. This concludes our incredibly granular exploration of D, providing public records, taking us through page 178 of your manual. This entire section is vital for understanding the practical mechanics of transparency and how public records requests are managed in Florida. Thanks for listening. In our next episode, episode 20, we'll cover the final major sections of Part 2, public records, including statutory exemptions, general principles, federal law and the Florida Public Records Law, fees for inspecting and copying public records, remedies and penalties, and maintenance, storage, and retention requirements, taking us through page 206 of your manual. So until next time, remember, the truth dies in the dark, so let's leave the light on.